This practice-perfect review addresses another long-recognized intentional tort, the tort of assault. Assault can usefully be compared to battery, another intentional tort. Battery provides a remedy when an actor intentionally causes a harmful or offensive touching to another. It protects the inviolability of a person's personal space. Assault protects people from the very expectation of such an intrusion. The mental distress that occurs when a person anticipates a blow or other bodily intrusion. The second restatement provides that an assault occurs when an actor intentionally acts to cause a harmful or offensive contact, or the apprehension of such a contact, and the act places another in apprehension of a harmful or offensive contact. That's a fancy definition. A couple of examples will help to illustrate the elements of assault. Suppose that Wilkins confronts his enemy Santoro in the street, raises his fist, and says, "I'm going to knock you into next week." Clearly, Wilkins has acted intentionally in the precise way that tort law defines intent. An actor acts with intent in the intentional tort sense when she acts for the purpose of causing the tortious result, or she acts knowing to a substantial certainty that the tortious result will happen. Here, Wilkins confronted Santoro for the purpose of placing him in apprehension of a blow, an unwanted harmful touching, and his act places Santoro in apprehension of being hit. So, Wilkins has committed assault. Or suppose that Flowers sees Brody walking down the street, steps in front of him and points a handgun at Brody, demanding his money. Surely this would place a reasonable person in Brody's position in apprehension of being shot, a harmful touching. Flowers acts knowing to a substantial certainty that he will place Brody in apprehension and has a purpose to do so as well, so Flowers has committed assault. To commit an assault, it isn't necessary to actually be able to cause the threatened contact. The actor need only have intent to cause the apprehension or expectation of the contact. Suppose that Flowers' gun is a fake, but it looks like a real one. Here, when Flowers steps in front of Brody and points the gun at him, Flowers has the purpose to place Brody in apprehension of being shot, even if the gun only puts out a little flag that says bang when you fire it. The act of threatening Brody with it would be an assault. It's often said that the actor need only have, quote, apparent presentability to cause the physical invasion in order to commit an assault. If it reasonably appears to the victim that he is about to be battered, then the actor commits assault, even though he cannot actually cause the touching that the victim anticipates. In Flowers' case, Flowers cannot actually cause a touching to Brody by pulling the trigger of the toy gun, but his act will lead Brody to anticipate a harmful touching, as long as Brody would believe the gun was capable of shooting him. An assailant commits the tort of assault by threatening such an intrusion, even if the victim knows that she can avoid the touching by self-defense or by fleeing. Suppose that Milquetoast, a small, wimpy guy, walks up to the heavyweight champion of the world, shakes his fist in Champ's face, and threatens to punch him into next week. Would that be an assault on the champ? Yes, it would be. Milquetoast has threatened to make an unwanted contact to Champ, so Champ expects to be punched. Of course, Champ can avoid the blow by self-defense, but he's still threatened with an unwanted touching, and Milquetoast has no right to do that. Although Champ is not afraid, he does expect an unwanted contact from Milquetoast. The anticipation of the contact suffices. Fear is not required. As is true with battery, the assailant does not have to threaten to directly touch the victim to commit assault. You can assault a person by throwing a rock at her, or driving a car towards her, or setting a dog on her. The secondary statement defines assault as intentionally placing the victim in apprehension of an imminent, harmful or offensive contact. If I see you here on the street next week, I'll break your neck, is not an assault, because it doesn't threaten an immediate intrusion on the victim. Threats of future harm may be very disconcerting, but they aren't quite the same as the threat of an immediate physical beating. The victim threatened with a future battery may take other steps to avoid the threat, such as going to the police or avoiding the assailant. And threats of future harm have a certain quality of uncertainty to them. They may represent mere bluster, rather than a real intent to harm. Just how imminent does a threatened contact have to be assault? Well, the victim must expect the intrusion without significant delay. If she sees her enemy running at her from 100 yards away, wielding a knife, that would very likely be held an assault. But a phone call from across town saying, "I'm coming to get you," probably not sufficiently imminent. Yes, there will be close cases on the imminence requirement, and in those cases, the jury will apply common sense in deciding whether the circumstances made the threat likely to lead the victim to expect an immediate blow. A good many courts have said that you cannot commit an assault by mere words. The words must be accompanied by a physically threatening act. For these courts, standing in front of your enemy, smiling and saying, "I'm going to break your head," would not be an assault, unless accompanied by some physical gesture like a raised fist. But other courts would likely be more flexible about this requirement. These courts would ask whether the assailant's threat, even though only words, together with the circumstances in which the words were uttered, would place the ordinary reasonable person in apprehension of a battery. Suppose, for example, that Flowers and Brody had had a serious argument at school that day. As Brody walks home through a dark alley, Flowers appears and says, "I'm going to get even with you right now." These particular circumstances would probably lead the reasonable person in Brody's shoes to anticipate a blow, even if Flowers doesn't raise his arm. Many courts, following the second restatement, would allow a jury to find assault on these facts if the victim does apprehend an unwanted contact. Suppose that Flowers throws a rock at Brody, who is not looking his way, and the rock misses Brody. Here, Flowers has not committed assault because he did not cause Brody to anticipate being hit by the rock. The essence of the tort is the victim's anticipation of a battery. If the victim doesn't anticipate an unwanted contact, he doesn't suffer an assault, even if the assailant actually tried to assault or batter him. Traditionally, criminal law defined assault as an attempted battery. If Flowers hurls the rock at Brody from behind, trying to hit him, Flowers would commit the crime of assault, but he wouldn't commit the tort of assault. Be careful in your studying to distinguish criminal law definitions from those that apply to torts. Sometimes an actor may make a threatening statement, but the statement itself makes it clear that the actor isn't going to carry out their intent. If Flowers accosts Brody in the schoolyard, raises his fist and snarls, "If we weren't on the school grounds, I would punch you out," here Flowers' statement itself negates the threat. He's saying that he would hit Brody if they were somewhere else, but he won't do it here. Similarly, "If you were not an old man, I would knock you down," is not an assault, because again the statement indicates that the actor is not going to knock the victim down. However, making a conditional threat will be an assault if the assailant tries to force the victim to abandon a legal interest in order to avoid a battery. If Flowers sees Brody in the road and says, "If you don't get off this street, I'll run you down," the threat is conditional, isn't it? Here, Brody can avoid the contact by complying with the condition, by leaving. But Flowers has no right to force Brody off the public street. So Flowers is really saying, "If you stand on your rights, I'll run you down." That is an assault. Various concepts about the intent requirement that apply to battery also apply to assault. You may want to revisit the Practice Perfect review on the meaning of intent to refresh your memory on these intent issues. For example, the doctrine of transferred intent applies to assault as it does to other intentional torts. If Flowers throws a book at Brody, meaning to hit him but misses, Brody will have a claim for assault if he sees it coming. Because Flowers meant to commit an intentional tort, battery, his tortious intent will transfer to the assault that he actually caused. Similarly, if Quick is standing next to Brody, when Flowers throws the casebook, and Quick sees it coming and is afraid he'll be hit, Flowers has assaulted Quick. Here, Flowers tried to assault Brody, but placed Quick in apprehension of the contact. Again, having acted with tortious intent, Flowers will be liable if he causes the tort to a different victim. Put another way, Flowers cannot escape liability just because he has bad aim. Similarly, a mistake by the assailant as to the identity of the victim will not prevent liability for assault. Suppose that Flowers has bad eyesight and sees a man standing at the corner and thinks it's Brody. So he throws his book at him to scare him, but in fact it isn't Brody, it's his classmate, Langdell, who sees the book flying at him. Flowers might argue here that he had no intent to place Langdell in apprehension of a harmful touching. He thought it was Brody and only meant to hit Brody. But Flowers did have tortious intent. He meant to place the person he saw in apprehension of a harmful touching, and he did. Even though Flowers was mistaken about who the victim was, he will be liable to Langdell for assault. He acted to cause apprehension to the person he threw the book at, and he did cause it. Flowers' mistake about the identity of his victim will not protect him from liability.